calling this meeting back to order. Mr. Clerk, will you please read in Bill 214?
Bill 214, amend Section 25-8-33, City of Hilo Zone Map, Article 8, Chapter 25, Zoning Code of the Hawaii County Code 1983-2005 edition by changing the district classification from multifamily residential 2,500 square feet RM-2.5 to multifamily residential 1,500 square feet RM-1.5 at Waiakea, South Hilo, Hawaii, covered by tax map key 2-4-028:009. Applicant Vincent T.C. Tai, area 3.292 acres. The Windward Planning Commission forwards its favorable recommendation for the change of zone to allow the development of an 88-unit affordable housing project known as Hualalai Court on Hualalai Street in Hilo. Reference Communication 718, introduced by Mr. Kern by request.
Thank you, Mr. Chair. May I have a motion to approve Bill 214 and send to Council with a positive recommendation?
So moved. Second.
I have a first by Mr. Erlogan and a second by Mr. Kanuha. We have the applicant, Vincent Tai in Hilo. Applicant and or the representative, please come forward. Could you please introduce yourself?
Yes, my name is Vincent Tai. I'm an architect. My address is 2184 Round Top Drive in Honolulu.
Okay, very good. Do you have any opening statements you'd like to make before we get into any discussion?
Yes, I do. Let me first answer Mrs. Nishida's statement just now.
Can I, excuse Mr. Tai, I'm so sorry. I'm going to actually hold you to stop for just 1 second. We're having a hard time hearing you.
Okay.
Would you try to move away from your microphone a little bit, and we'll turn the volume up
Okay.
and see if that works.
Is it better here?
Just do a test.
Is it better?
It's a little better on clarity, but not quite on sound. Can you go higher?
How about now?
We're going to take just a quick recess. Stay right there, Mr. Tai. We're going to just go back and forth to get this sound straightened out while in recess.
Okay.
We're recess.
Thanks.
Donna, can you please go to the testifier's mic?
It's kind of hard to hear lower voices.
I'm not able to hear any of what he's saying.
No,
Yeah.
like even like your
Testing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10.
Okay, that sounds good. Sounds good, Donna.
Yeah, I think that's
Okay.
great.
At that distance, okay.
And just for you, Mr. Tai, can you say a few words?
Yes. Can you hear me now? Is it clearer? Better?
Yeah, that's going to work for us. All right, thank you very much. We're good? Okay, calling the meeting back to order. Mr. Tai, you may begin.
Oh, yes. This is in response to Mr. Nishida's statement just now. In general, yes, it was agreed with the conditions that we mentioned, except for a couple of clarification there. Well, first of all, the Planning Commission first proposed to recommend unfavorable recommendation was because I didn't have the chance to meet with the neighbors, and it's just my fault. I didn't understand that was the only time that the public can speak. I thought they would have a chance to do so, and I've had a chance to meet with them before the planning approval of the project. So that was my misunderstanding of the process. So I did meet with all of those who attended on all the conditions that was stated by Mrs. Nishida, but I want to clarify two things. First, the minimum setback will be 20 feet versus 10 feet for all the side yards. But in all our correspondences and in writing, and this is only for the properties that's fronting on RS 7.5 zoning, because There are other zoning next, adjacent, contiguous to my property. The one to the north of it is already zoned RM 1.5, and those to the, I would say south, there's, they're either 1.5 or 1. So I stated that I would be willing to set back 20 feet, which is double the allowable code allowance. For those properties is fronting contiguous to my property that are zoned RS 7.5, except for one property to the north. There's only one property there because that property also zoned next to other 1.5, RM 1.5 that didn't have the requirement. So I did agree that I would do for every properties that is adjacent to mine that is zone RS 7.5. And also the same thing for the 6-foot chain link fence. And I agreed to put a 6-foot chain link fence along the property line that are fronting properties that zone RS 7.5. And it was very clear that it was made in that manner, the agreement. I think Mrs. Nishida would agree to that because it's very clear. I just want to speak briefly because I did write to the council members on my project. First of all, I'm changing it from a already approved RM 2.5 to RM 1.5. In fact, the two projects are a little different. The reason that I need a little bit more density is because I'm building, my proposal is for 100% affordable or workforce housing, between 60% to 100% AMI. I'm not even doing 140%. In fact, this is what people do when they try to do affordable housing to satisfy inclusive housing requirement, affordable housing requirements. And as far as I know, there are none project in the east side of the county of Hawaii for the last, I don't know, many years, 30 years, 40 years, they have been no affordable housing, or we call workforce housing, between 60 to 100%. Most of the affordable housing are for low income, but none for the workforce. So I believe this is the first project, unless there are projects that I'm not aware of. Now, the comparison between this one versus the one that's already approved, which is based on RM 2.5, that project is only about 59 units, something like that, but they're bigger units. They are 2 bedrooms and 3 bedroom units. Now, this one, once I rezone it to RM 1.5, because they're all affordable units, they're 96% of the projects are either mostly 1 bedrooms and studio units. So when I have to have more units counts to make up the floor areas to make the project works. It's very difficult to make project works in Hilo, particularly building affordable housing between 60 to 100% AMI. So when you compare the two, actually this is a smaller project, even though the unit counts are more, just because the units are smaller. So the less bedroom count and less floor area, therefore less parking demand. And also, I'm setting the side yard much bigger than the previous one. There are a lot more open space, a lot more existing vegetation to be retained. So it is really a smaller project, even compared to the RM 2.5. So on that basis, I would hope that my intention is clear. I'm not trying to build a bigger project than the already approved RM 2.5 proposal. So, is there any questions?
Thank you, Mr. Tai. This will now get into discussion. Is there any discussion from my fellow council members? We'll start with Ms. Willie, and then we'll go to Ms. Ford.
Can I ask Ms. Nishida, who's in Waimea, to if she'd like to make any comments on the presentation or questions? Ms. Nishida?
Hi, thank you. We met with Mr. Tai at the community meeting in good faith to come up with compromises as neighbors. We're single family. His development is multifamily. It will increase the density. It will affect our property values. It will increase less privacy, more noise. We did come up with an agreement.
Ms. Nishida, I'm going to hold that. I need you to answer that question directly about those specific conditions, not move into further testimony.
Okay.
That would be kind of crossing over the line. Ms. Willie, do you want to restate your question?
Yeah. Do you have any particular questions, just in terms of the testimony that you might want me to ask?
If Mr. Tai is agreeable and the county council will approve the conditional requirements that were agreed to at the community meeting.
Okay, thank you. So I'd like to ask him the question.
Well, I think the question is there's a representation by the testifier. There's been a representation by the applicant of what they're going to do. I think the question probably would be to the applicant to the testifier is what the applicant expressed. Is that acceptable to her as far as those conditions?
Yeah, right. So I'd like to ask the applicant, just in terms of the community meeting and your agreements or that you all worked on, are you, just to be clear, is those firmed up, or are you agreeable to those, or are there still issues remaining?
No, those issues that Mrs. Nishida brought up, I have already agreed upon, with the exception that I mentioned, that the 6-foot fence is for those property lines that is contiguous to RS 7.5 single-family zoning, and also the 20-foot setback applicable to all the properties that are zoned RS 7.5, except for one only, which is up in the north. I stated all this very clear in my correspondence and in my letters to the planning director, and it was quite clear. I was just surprised that Mrs. Nishida didn't include these conditions.
Okay, I yield.
Okay, thank you, Ms. Willie. Ms. Ford?
Thank you. The lady who testified, the mics are not so good today.
Yeah,
so you wanted a 6-foot tall fence all the way around the facility, or only as the applicant stated along the RS 7.5?
As the applicant stated.
Okay, and the 20-foot setback, again, only along the properties that have the RS 7.5?
Correct.
Okay, and what was the third one again?
An on-site residential manager an on-site manager for the development.
And did he agree to that?
He did at the as one of the conditional requirements through the community meeting.
All right, thank you. I'd like to call Director Kanuha forward,
and
please.
I'm sorry, there's one more, that it was limiting the building height to 2 stories.
Thank you.
And then the last one was that the rock wall would remain in place along his property and the adjacent RS 7.5 properties.
Thank you. Director Kanuha. Dwayne.
Director Kanuha, will you please come forward? Good afternoon.
Please identify yourself, sir.
Good afternoon, Dwayne Kanuha, Planning Director.
Thank you. Now, Mr. Director Kanuha, you are very soft-spoken. I want you to speak up, okay? These mics are not very good today. I don't know what the problem is.
Okay.
Thank you. I got that one. Originally, there was an unfavorable recommendation. Was it strictly due to oh, maybe you should tell us what it was due to, the original unfavorable recommendation.
I was at the meeting. My recollection was it didn't appear to me that the commissioners were getting answers to questions that they were asked. Mr. Shida also participated in all of those meetings, and so they took a vote, and the vote was to pass up an unfavorable recommendation. Mr. Tai requested they reconsider, and I forget if he offered to meet with the community. I believe that's what happened. He offered to meet with the community, and the commission made that a condition of reconsidering their vote, something along those lines.
Okay, thank you.
And that was the same representation Mr. Tai gave, to just clarify his right now. Okay.
Thank you. One of the things that I'm seeing in here, and I would like you to clarify this, he talks about workforce and affordable housing. To me, there's actually different. Would you explain to me, at least, the difference between workforce housing and affordable? Because over in our side of the island, affordable is a lot less expensive than workforce housing.
Well, I think it's nothing we require or we're requiring as part of the request. It's what he is proposing, and obviously, whatever it is, we all agree that it's needed, either workforce or affordable. Yeah.
All right. The other day we had a meeting on a different subject, and by the way, I apologize. I think it was, for the most part, a waste of your time, but that's another issue. But during that meeting, we had a discussion about the credits. When people build housing and they build more affordable housing than they're required to, they get these extra credits, which then can be sold on the open market, sometimes for pennies on the dollar, and the developer can come in and say, you want 20 or 30 or something affordable houses, here's my credits, and I don't have to build anything. How do we make sure that these houses get built as affordable housing?
Can I get my part?
Yes, sir.
If you take a look at the ordinance, I guess condition P is basically the standard condition as it relates to housing, and it refers back to the requirements of Chapter 11.
Okay,
affordable housing policy.
Doesn't Chapter 11 just say 20%, or does it say that in the Chapter 23 or 25? Because right here, that's our standard language.
That's your standard language,
but
right?
It doesn't tell me what percentage of units there are. So is it 20 or is it going to be 100%? Legally, we can only ask for 20, right?
Whatever Chapter 11 calls for, that's what it asks for.
So that's 20%. And how many total units? On one document, I see 100 units. Is 100 units the actual number?
I believe that's what it is, yes.
Because that's not in, and on what basis was 100 units determined?
But as you, it's in the record, and as Mr. Tai just indicated, that he is proposing to far exceed that ratio.
How far?
I believe it's, well, it's up to, I think 62 100% is basically what he's represented. I think he just...
How many units, how many total units in this subdivision? 100.
Yes.
Okay. And whatever he builds above the 20% is what he chooses to build, correct?
Correct, yes.
Okay. So these 20 units that he's going to have to provide as affordable, he could use the credits. He could buy credits from some other developer, as they said, at pennies on the dollar, and not build a single affordable unit, correct?
If that's what he's allowed to do under Chapter 11, yes.
Okay. All right. As you know, I'm not happy at all with Chapter 11, but I can't do anything about that. So, and these 100 units, what is, based on the square footage of this parcel, what is the number of units he could build?
I think he's building up... Hang on a second. I could probably find it, but maybe he can answer. He can answer it better than I can right now.
Just stay there. Mr. Tai,
Yes.
how many total units are you planning on building?
Well, the proposal is, for now, is 88 units. 88 units. Maybe it could be up to, I think 105. I'm not certain. The point is, I'm making entire project 100% affordable or workforce. May I speak a little bit about what the difference between so-called workforce and affordable? May I do that?
Yes, you may, sir.
Yeah. Well, actually, okay, they're all affordable, okay? I think in the state of Hawaii, their definition for affordable is to serve people under a certain income group. It's from like 30% of the medium income group. Now they call AMI, which is area medium income, because like Hilo's income may be less than Honolulu's, okay? So they call AMI, area medium income. It ranges between like 20-30% all the way up to 140%. That means it could be 100% more than the median. A lot of people, when they try to satisfy the affordable housing requirement, like the inclusive, like you mentioned, 20%, they build 140%, because then they are not actually building affordable unit, but by law, it's still affordable. Now, my proposal is to build between 60 to 100%. This is one gap that is missing in the state of Hawaii, not just in the Big Island here, even in Honolulu, because this is the group that are priced out of the market rate, which is basically 140%, and they are not qualified for the low income, which is like 30%. So they're in between. And these are the people that needed housing most, either rental or by purchase. And these are ordinary folks. These are not poor people who cause trouble, like some of my neighbors, kind of concerned. These are people who may be firemen, policemen, teachers, nurses, students, just ordinary folks. They get trapped in between. Now, my proposal is to between 60-100% depending on the financing. I did some legwork on the financing of these kind of housing. It's not easy. If I can get certain kind of financing, I can do the 60%, which is make it a little easier, lower in rental and purchase price, or 100%, a little bit higher, but still, below the medium. This is about average. They call AMI, right? Now, so workforce, when they say workforce, most likely they talk about between 60 to 100% AMI. But in some area, like in Honolulu, it's between 100 to 100%, 140%, they call workforce. Workforce just mean for working families. So don't be confused with the two, because workforce is actually part of the affordable. It's just a certain bracket of the income group they call workforce. So in our case here in a Big Island, is anywhere between 60 to 100% is considered workforce. People, just ordinary folks. Okay, so I hope that clarify here. But in terms of this project, I seriously meant to develop entire project 100%, not just to satisfy the 20%. Okay, now talk about those credits you can sell. In fact, as far as I know, it doesn't really happen in Hilo or this vicinity here because it only applies for people who are building new projects, but there's no new projects building. Very few. I mean, for the last 30 years, most of these so-called substantial projects, like 50, 100, 200 unit condos or multi-family, they are very old. So even if you have these credits, I don't know who can buy it because you have to sell within 15 miles, if I understood correctly. You have to sell to a project that's built within 15 miles, or your credits to be sold has to be within 15 miles or 5 miles. I forgot, maybe the planning director can correct me. I believe it's 15 miles radius. If you're outside of that, you cannot sell your credit. So, but since
704, please.
Communication 704, 2013 Annual Report of the Public Access, Open Space, and Natural Resources Preservation Commission from Mayor William P. Kanoy, dated February 20th, 2014, transmitting his comments and recommendations regarding the Commission's 2013 Annual Report submitted to the Mayor pursuant to Hawaii County Code Section 2-217. The Mayor provides a detailed summary of the purchasing history and the status of the lands purchased with the fund, an accounting report, a statement on management and stewardship of the lands, and requests that the Council accepts the updated prioritized list as provided by the Commission.
Councilmember Willie, may I have a motion to file Communication 704?
So moved.
So moved by Councilmember Willie, seconded by Councilmember Kanuha. Discussion, Councilmember Willie?
Okay, this is the mayor's report on the different priority properties for purchase with the 2% land fund. And I think at this point, it's really just to educate us on the different ones. The one that people have testified is one of those in here. There are a number from around the island, including there's a map of those that are here on one of the first pages. So this isn't something where we're voting for one or another. I think that it's important to take a look at what the different issues on each of the priorities. So these are the priority items that the mayor has accepted from the Public Open Space Commission. So
thank you.
I yield.
Okay, thank you. Any other discussion on the report? Okay, so Councilmember Eoff?
Okay, I'm sorry. We're just discussing filing this communication.
Yes, just to file the report.
Well, I just wanted to add, because we had a great purchase at the end of the year that wasn't included in this book because it got published before December 31st. And just so the public knows and everybody, I just wanted to say thank you again to Mayor Kinoy and to Ken Van Bergen for negotiating the purchase of O'oma beachfront property, which was long sought after by the community, maybe over 30 years of work to keep it open and keep the public access there for the community forever. It's a beautiful white sand beach, and the purchase allows us to extend the Kohaniki Park all along the shoreline between Kolokohonokau National Park and the Natural Energy Lab, OTEC, is now all owned by the county and is a public shoreline beach. So forever in perpetuity will be there for people to access and gather and fish and surf and camp and enjoy with their families. So I just wanted to mention that and say thank you again.
Thank you. Any other discussion? Seeing none, we'll do a voice vote. All those in favor say aye.
Aye.
All those opposed? Okay, so Communication 704 is filed. Mr. Clerk, will you please read in Resolution 332-14?
Resolution 332-14 authorizes the Director of Finance to enter into negotiations for the acquisition of tax map key 5-5-015:042, known as the Banyan Trees Park area in North Kohala, pursuant to Chapter 2, Article 42 of the White County Code, 1983-2005 edition as amended. The Banyan Trees Park area in North Kohala, 0.91 acres, is listed as a key priority for purchase in the 2013 annual report of the Public Access, Open Spaces, and Natural Resources Preservation Commission. Reference Communication 732, introduced by Ms. Willie.
Ms. Willie, can I have a motion to approve Resolution 332-14?
So moved.
Second. It's been moved by Councilmember Willie and seconded by Councilmember Ford. Any discussion? Councilmember Willie?
Yes. I think if anyone who's been to Javi were to say, where is the heart, soul, spirit, the common heart for the community of Javi, it would be this place next by the banyan tree, this grassy open area. This is where the community comes together. There's no other public common space in Javi. The North Kohala CDP emphasizes all of the elements of preserving such a place for the community and for future generations, whether it's keep Kohala, preserve sense of place, importance of public trust, not just for the environment, but for cultural identity, which is also incorporated into our charter, Section 1329, Conservation of Natural and Cultural Resources. So I think I don't need to go back over and I think reinforce all of what everyone said. I would like to make a few remarks, and I would like to bring forward David Lucas and Shelley White, the owners of this property, if you'd like to come forward. And I want to say that this is putting this together. This is a private piece of property owned by a couple who bought it with their own personal dream in mind. They are members of the Kona community and have spent much of their lifetime working on preserving historic buildings in Hualalai, understanding the importance of community and coming together. And out of the efforts of people such as Gail Burns and Craig Williams, Chris Helmuth, Bob Martin, Karen Rosen, including Bob Chantel, many people there in North Kohala working together came to them and said, you know, will you give up your dream for our dream for the future of our community? And they have been willing to do that. I do want, so here you have the whole community coming together and working and saying this is our one little green space that's all historically been where we come together, and is there a way to preserve that? So part of it is also the urgency. They have it. They've been planning to build. They're going to do something there. And it's like they've been renting property to allow the community to pull this together and try to make it work. There have been community monies put in to support this. I went to the senior meeting. Every senior there stood up in support of this, how important it is, over 500 signatures. One last comment, and then I'm just going to ask you all to make a few comments here, is just looking at planning and future planning and some of the different consultants that have come in. And I can remember one I went to in Honokaa, and they said, here's how, let's take a look at different communities around the island, and which one do you aspire, and which one is, and they did Honokaa, and with that green area and the little village, the pedestrian access, and everyone there said, that's a model. I mean, that was just so central in terms of planning, good planning, planning, economics, environment, culture. So the key thing, though, I want to say, there is an urgency. We vote. It still takes the mayor to say yes. They're sitting, renting a place, waiting to hear a response from the community. So I just want you all to share. This is like epitomizes graciousness and generosity and love for this island. So I just, if you'd like us to say a few words about this.
If you could press the button at the base.
There we go.
And state your name for the record before you proceed.
Dave Lucas.
Thank you.
Okay, so my wife and I have actually looked at that property off and on for 20 years, and it's sold several times, it's changed hands. And we sold a beautiful 20-acre farm in Hualalai, and then the park property became available, and to us it was a dream. However, I will say that the fellow that we bought it from, we asked him, isn't this like the town park? And he said, oh no, they know it's commercial, they know it'll be developed. So that's kind of what even took us over the help make our decision. And then once we got up there and spent time up there and talked to many in all aspects of the community, it became clear to us that it really was the town park. And as a former park ranger in a past life and a lover of open space, you know, we just have to give up what is a beautiful piece of property. And I mean, it is beautiful, and it's our dream, but we're willing to give it up for the people. I mean, why not have everybody enjoy it? And so I think that's what it's come down to, and hopefully the mayor will see that. And I do, though, want to say, as you communicated to me, there is some urgency. You're meanwhile spending money, renting, not, if you just know for sure it's going to happen, you're good. But if this just goes on and who knows when, well, and the window of opportunity, that you're just not there to sit around and, well, when the county decides to do it, we'll just hang out. That's not the issue here.
We're not young.
Okay. Okay. Thank you very much.
Hi, I'm Shelley Lucas, Shelley Maudsley White, the artist, and thank you for this opportunity. And you know, I've kind of been on a roller coaster with ups and downs about it because it was really a wonderful opportunity to acquire it. It was magical, and you know, I heard all these testimonies and stuff, and what I would like to say is we didn't have a plan to do something horrible there. You know, we wouldn't do that. We went actually to the county and we spoke with Billie Jean Lighthouse Todd, and we read the because it is commercial, we read the planned community development, you know, the 430-page thing that the Kohala had, and we had aligned our plans to accommodate that and to actually make it a beautiful space. The plan that we had to do would have been beautiful, but then, you know, as we were going ahead with our plans, we started getting the feedback from the community. And you know what? We're not selfish people, and this community is very passionate about their space, and so we're totally willing to surrender whatever plans we had so that this could be shared by all of the people for you know, on the island. I grew up here, raised all my children here. Dave and I have lived in Hawaii on the Big Island for many years, so we can definitely appreciate beautiful spaces, and we just hope that the county would purchase it for a fair price so that we can go on with our life. We've been waiting 10 months while the community's been trying to get it together. We can't afford to buy anything while we wait. We're just kind of like in limbo with our life. So that's what we hope you guys do. So thank you.
Okay.
Thank you.
I yield.
Okay. Councilmember Ford?
Thank you. You are doing a very commendable thing for the island and for the community, and I personally thank you, and I support this. But I have to ask Mr. Van Bergen to come up and talk to me a little bit. Yeah, please step back, please. Don't go far. Somebody else may have questions for you. Mr. Van Bergen, would you identify yourself, please?
Ken Van Bergen, property manager.
Okay. Mr. Van Bergen, as I look through this, the one thing I'm going to say is I understand the county cannot pay more than fair market value, period.
Appraised value.
Fair appraised value, okay, by an independent appraiser. It's not our personal appraiser, it's an independent, somebody
A third
outside.
party that we hire, yeah.
A third-party appraiser, thank you.
Yeah.
However, as I look through this document, there's not one bit of information about even the potential value of this parcel. I can't tell if it's $1, which I'm sure it is not, or if it's $1 million.
The assessed value is $550,000. So
$550,000
Yeah.
is the current assessed value.
well, yes.
Okay. Just as a comment, I think that information, this is not your fault. This information should be in the document someplace so we know what it is and the public knows about what we're going to negotiate. That doesn't mean it's going to come in at $550, may come in higher. When the appraisal is done, it may come in somewhat low. We don't know. But I personally, I've noticed this throughout the papers today. We're just not getting any idea of what it might be. But I will support this. I will support it. Thank you very much.
Thank you. Councilmember Kanuha?
Well, thank you, Madam Chair. I support this as well. I just wanted to have clarification about this actual park. I've been there before, but when I look at the TMK, it's, this particular parcel is 0.9 acres, below an acre, pretty much. And when you look at the picture that you've given us of the entire area, I'm trying to figure out if this is just a quarter of the park, of the entire park, or half of the park, or I don't know. And there seems to be a parking lot in a different TMK. And a lot of the trees, these big trees, are also in different TMKs, that the community is talking about. So I'm trying to figure out, in this particular parcel, what exactly is the community going to get by the purchase of this property?
Well, basically, when you get the 0.91 acres that identifies, one thing that the map is skewed slightly. The overlay, the GIS TMK overlay, you got to scoot it to the left a little bit to be more accurate with what the actual property is. So some of those trees are on this property. Just the map's a little skewed. It's just the technology of the GIS system. There are other TMKs. This isn't the whole area, so there are other TMKs that have
those are other private interests.
I actually haven't looked up the parcels around there, so I couldn't tell you right now.
I don't, as a person just looking at this, no knowledge at all. Just trying to figure out exactly, is this a purchase of the entire park or just half the park, or?
And when we say park right now, there's no park.
Yeah.
It's all private. Okay. So this is
park in quotations.
This is basically the open area. Where it goes up. It doesn't. If you were to go to here, stand and start hugging the banyan tree, you'd now be on surety property. So, and there's, I think it's the Catholic Church. If you want, I could bring one of the testifiers in North Kohala forward for more detail. But it's this is basically the area that's opened, the grass area. If you look over there, so.
Okay, just wanted to find out more information. Thank you.
And one thing you can do, Councilman, is if you look on the map that you're looking at in the annual report, you see the white building next to it?
Yeah.
And you see the road parcel that kind of goes over that building? Yeah. Just skew that over to where the road is, and that's kind of how far off it is. So
yeah, I see what
it's pretty much when the cars over to the right is the 0.91 acres, so it's the whole grass area.
Got it.
Yeah.
Thank you.
Okay, thank you. Any other discussion?
For the last 20, 30 years, even you have these credits in hand, they don't worth anything. Now, I can't say in the future, but these are not the incentive for people who want to build affordable housing. Here in this case, I'm not building it just to satisfy a minimum requirement, 20%. And I'm not building it because I'm looking for these credits, because the credits, it's meaningless at this point. I hope I make myself a little bit clear between workforce versus affordable.
Yes, thank you, Mr. Tai. Regarding these commitments for the setback, the fence height, the limits to 2 stories, the rock wall, and the on-site manager, do you have any problem with us putting those conditions into this document, into the ordinance?
No, I have no problem. In fact, I offer to comply with those agreement, except I want to make it clear that Mrs. Nishida was not 100% correct, because like I said, the 20-foot setback is for all the properties that's adjacent to RM 7.5, except for one, which is north of it, just one, okay? And then for the 6-foot fence, also, it only applies to the boundary that is contiguous to those zoning at RS 7.5. The stone wall, the very low stone wall, and no reason it should be taken out at all, unless they are totally crumbled, okay? So I have no problem with that. And 2 stories, and I propose a 2-story building. I don't think one can even afford to build a 3-story building affordable, because then you require elevators. 2-story is the max one can go. Even that is a little difficult, given today's cost of construction and the limitation of rental and sales price, because of the 60 or 100% AMI.
Mr. Tai, I want to thank you and also commend you if you actually build these units up to 105 units into the 60 to 100%, which I've been advocating for probably at least 6 years. 140% is exactly as you say. That's market-priced housing, and it's not affordable. Thank you very much, sir.
Thank you.
Thank you, Ms. Ford. Mr. Onishi.
Thank you, Mr. Chair. Hi, Mr. Kutnuma. I think you were the director at the time when this person on Kinole came for rezoning to do that student housing. Were you on board at the time?
Whereabouts on Kinole?
It was like in between Ohio Street and Kawili Street. He wasn't.
I don't think so. Yeah, I remember that on commission.
You guys remember?
I think that was.
Okay, so the testifiers mentioned about these conditions and things like adding them on, but I know with that project we couldn't do that. But what the applicant did was, I guess they put it into their conveniency, I guess, paper or the document to say that this is what they were going to do. I mean,
are you talking about a proposed condition or agreement to what he's going to do?
Yes. Yeah. Okay. So what is the option that, because the testifier is mentioning to put it in the conditions, but to make the fences high and so forth. I mean, that we cannot do that. Correct.
I think you can. I think what you need to do is to, if you want to add that as a condition, I think the safest way is to preface the condition by stating, as agreed to by the applicant, because it doesn't become a new requirement.
Because like I was saying, when that other applicant came in, I guess I was told that we couldn't do that, so that's why they made like a separate agreement. Like they put it into. I know the applicant got his attorney to write it up. The agreement with the community, like having like this buffer zone and having a fence like this in this case and so forth. But planning at the time told me that we couldn't put it in the conditions.
I'm not really that familiar. I don't see an issue with a condition like this. Again, all I'm saying is as long as it's preferenced by, as agreed to by the applicant.
Okay. So I guess maybe my office can work with yours, with your department, and we can come up with those amendments to the conditions, so that way the testifier, was the agreement that they had, it's going to be in black and white.
Yeah, and I think what I'm weighing here is not to go too far in amending the ordinance, because then it may have to go back to the Planning Commission. You see what I'm getting at? So I think this particular condition, and the record shows that the applicant is agreed to it, that if he preferenced by the condition by saying as agreed to by the applicant, then I think we're all good.
Charlene, in Waimea.
Hi, yes.
Okay. So, you know what? Well, what I'll do is I'll check back with my staff on what we did with the other project that was in my district, and what the applicant did, how they wrote it out. Would that be okay?
Meaning that there'll be conditional requirements adopted by the council, the county council?
Or like whatever, the agreements that the community had with the applicant. We'll have the applicant, I forgot what we did, but it was separate. And like I said, earlier, is that at that time when that applicant came in for that other project, planning department told us it couldn't be added into the conditions, but so they made a separate agreement form, or, he wrote up something, and so I'll check with that. And
the meetings with the planning department, they actually said that we could, that what was being asked was reasonable conditional requirements that could be, and that was in discussions with the planning department, and I have emails confirming that. That these things, and they're minimal, that they could be placed as conditional requirements.
Okay.
And that was, and I have those documents I can actually forward to you that actually verify that.
But then, like the director is saying, but if we do too much or exceed too much, then we're going to have to send this back to the planning commission.
But they're not. They're not too much. And it's something that.
I think the reason it'll be okay is that it's because it was prior discussion. I mean, it's on the record that this was talked about. It's not something new that the committee decided we just want to stick in. So, my assessment, it's a pretty safe.
So we should be okay?
Yeah.
Okay, so we'll have my staff work with the planning department to get the amendments in there. Okay?
Thank you.
Okay, thank you.
Thank you, Mr. Onishi. Ms. Eoff?
Thank you. Can I ask Mr. Onishi a question?
Yes.
This is in your district, correct? Do you think we should postpone here in planning committee while we see, so we can see the amendments come back to us and make sure everything's stated?
Well, I don't think so, because it's just adding them, and then we can do them at the first reading at council. Yeah. Because this is agreed upon with the community and the applicant already. And the director is saying it's minor, so I don't think there's any more discussion.
I do.
Thank you, Ms. Eoff. Is there anyone else on first round? Seeing none. Ms. Ford?
Thank you. I noticed this piece of land is landlocked. It's only got access coming in from Hualalai Street. And it is in violation of the code that says you can only have 18 lots in a cul-de-sac. And this is planning to have 105, more than 5 times the amount.
It's a complex, so yeah.
It's not, what?
It's not a subdivision. It's a housing unit.
You've got 105 units in here. If there's a fire, people cannot get out. Now, there is part of the RM 1.5 property is a private street called Kupu Street, which leads to Kukuau Street.
Correct.
Okay, we can't force them to allow an access on a private road.
May I speak to that?
hold on a second. Our code says that you can only have, on a cul-de-sac, 18 lots, 18 units. It's a public safety issue. I'm not trying to trash this thing. I'm trying to find out what you're going to do when there's a fire at the front end of this location and nobody can get out of the housing units. This is a cul-de-sac.
May I talk?
You can call it, excuse me, sir, you can call it a housing development, you can call it anything you want, but there's 18 separate, 105 at least, a maximum of 105 housing units. That is in violation of our code.
Except there won't be any on-site streets, okay? This is a vertical project. It's a series of apartments.
It's still on a single driveway.
Well, a cul-de-sac would not apply. A cul-de-sac would only apply to subdivision.
So you don't think this is considered a subdivision because it's got 105 units and these people will not be able to escape?
Multiple residential zone. It's not for sale. Well, I guess, yeah, it is for sale. It's in our opinion, it's not the equivalent of a cul-de-sac, no.
Okay, Mr. Tai, would you like to comment now on this?
Yes, I think the planning director is correct. It's not considered as a subdivision, and it's not considered as a cul-de-sac. Now, as far as exit, I mean to point out that the property north of my property, you mentioned that there's a street south of a case, something, right? I forgot. That street doesn't even exist. That was the old map. So the property right north to mine, owned by Mr. Bruschetti, and that's already zoned RM 1.5, and also he was proposing 3 or 4 story building there, over 100 units there. So in my planning, I have allowed a 15 feet gap between the groups of buildings, as you can see.
Yes.
That is to provide for future emergency exits. And I was told by the planning department that, see, it exit into a driveway on the other property, on Mr. Bruschetti's property. What he has is, his proposal is group all the buildings, these 3 or 4 story buildings in the middle of the site, and then they have a perimeter driveway. So this will exit into a driveway. So the proposal is to keep that 15 feet as emergency exit if needed, and there will be a gate that only used for emergency purpose for vehicular access. But even without that, I have gone through the fire department, public works, and this is not considered a cul-de-sac, and the 15 feet that I'm providing for emergency exit or access is really additional. Okay, so it's seen on the plan there, on the site plan. There is a 15 feet gap between the 2 buildings.
Mr. Tai, I see the gap. Thank you. Corporation Counsel, would you weigh in on this, please?
Yes. Good afternoon, Ms. Ford, Councilwoman Ford, William Berhanti, Deputy Corporation Counsel. As I understand the question, there's some discussion regarding whether or not the 18-lot subdivision code requirement for a single driveway or a single roadway access would be mandated to, or this project would be mandated to comply with. It's my understanding that this is a single lot. The TMK is 2428009, and it's a residential development for a multi-family residential housing development, and therefore it doesn't legally come under the description, and it doesn't meet the requirements of being individual subdividable units. So therefore, the subdivision code would not apply to this particular unit or development.
Okay. What's the definition of a cul-de-sac? One way in, one way out, right?
I think that would be a very simplified definition. I'm sure if we were to research it, there would be a much more technical definition. But
I'm sure.
But just out of just for informational purposes, as a commercial or a multi-family developmental project, the Hawaii County Fire Department planning inspectors, I'm sure, had an opportunity to review the plans prior to obtaining permits or the like, and even in this place, as it stands right now, the fire department, the qualified, professionals in the field will have the opportunity to vet the project as it moves forward. And I can, assure you that public health, safety, and welfare is utmost in their minds, and they'll be, the requirements will be incorporated into whatever the final project, ends up being.
Okay. Director Kanuha, on this diagram that we have received, it shows this Kupu Street as a private road. Is that already developed on those lots as a multi-story building?
Which street are you looking at?
And the road is that one.
Yeah,
Is that
all
lot already
all I have is the zoning map, which shows you the same thing. Yeah.
Okay. Is this parcel north of this proposed development already developed?
Okay, what was the question now?
The private road is indicated on this diagram.
The one that comes off Hualalai Street.
The private road that's indicated on this diagram under my finger.
Oh, okay.
Is that lot already developed into anything?
No.
Okay. I think Mr. Tai is very foresighted in putting a 15-foot wide alleyway, if you will, with, I guess, some type of a gate that may or may not be able to be unlocked in an emergency situation to evacuate people. But this is this kind of lack of connectivity between these kinds of subdivisions, I don't care what you call it, but, and getting out of there in emergency, from my perspective, is a public health, safety, and welfare issue. I'm glad he's putting the alleyway in there, but if this property next door is not developed, or is developed and they decide to build something right in front of the alley, then we've lost any advantage of getting these people out of that subdivision.
Well, again, as you can also see from the diagram, the main access is off of Hualalai Street.
Okay, I give up. Thank you.
Thank you very much. Any other discussion? Seeing none, all those in favor of Bill 214, say aye. Aye. Any opposed?
I oppose.
Okay, we have 7 in favor, 1 opposed, and 1 excused. Bill 214 will move forward to council with a positive recommendation. Mr. Clerk, will you please read in Bill 211 and its companion?